Welcome. Thank you for coming to the 2019 Labor Law Update report. I'm happy that you're here, and I am going to get started here. This is my quote: "What you don't know about HR can cost you." And a lot of small business owners don't realize the risk that they're undertaking as an employer. In fact, many small business owners think that they have to have 50 employees before the labor laws affect them, which is not true. So away we go. So this is our overview. We're going to revisit the Dynamex decision for independent contractors because that's come up again with more clarification. FLSA statutes have been clarified in the Supreme Court. Calculation of overtime pay on flat bonuses has been changed. Overtime pay for incidental time, this is due to Supreme Court decision affecting overtime. Class action is waivable now in arbitration agreements. If you have one, you should do that. The work rules evaluation by the National Labor Relations Board have been changed. An expansion of the definition of national origin under the EEOC has been expanded. Now there was a ban of English by an employer before, but this has been clarified. And now there's a mandatory sexual harassment prevention training for employers of 5 or more employees. You can no longer have a confidentiality in settlement agreements. They're redefined and expanded sexual harassment and the definition of that. Lactation in the workplace has been further defined. Equal pay clarification has been redefined, and the right to receive hard copy pay statements has been enacted. Of course, everybody knows new minimum wage requirements, right? They've gone up. And then I have something that's on the horizon for 2020. So, clarification of independent contractor. This is the ABC test that was handed down in April of 2018 by the California Supreme Court. And these are the conditions that an independent contractor must meet in order to be properly defined as an independent contractor, which is different than what the IRS says. IRS defines independent contractor differently. And of course, what's underneath all of this? They want employment taxes. So both the IRS and California. But primarily what happens is a lot of large corporations were misusing and misclassifying workers as independent contractors, and they really were employees. They were there for years and years and years. They were classified as independent contractors, but they weren't being given the protections and the rights of employees. So California says, no, we're not going to have that anymore. And what really brought this to a head was the class action suits of Uber and Lyft. And that's still out in being adjudicated. The sticking point is, for most employers, is the fact that the worker performs work that is outside the usual course of the hiring entity's business. So, for example, if you have a tech worker that's writing software code, for example, and that employer delivers a software package, well, they are delivering that worker as an independent contractor is really doing an employee's job because they are creating a deliverable to the employer's or the business's customers. That would be like me as a HR company, hiring independent contractors, HR professionals as independent contractors, and they're delivering services to my clients that are HR, that is considered to be hands down an employee. And by the way, feel free to ask questions as we go. Okay, wage and hour. The U.S. Supreme Court redefined how they interpret the Fair Labor Standards Act. And they moved toward a fair interpretation instead of which means a broader interpretation, instead of a narrow one. So this had to do with, believe it or not, a car dealer. The car dealer was not paying overtime to the service reps that bring the cars in for servicing. They weren't paying them overtime. And so they're saying, well, because of the way the law was written, that they were not entitled, that they were entitled to overtime. And in the past, because of politics, who's more conservative, who's more progressive in terms of how they treat employees, they have moved now to a broader, and so those people are now considered to be not eligible for overtime. So the impact is for an employer that it's easier for an employer to defend against claims for overtime. Now, keep in mind, that's probably not your average worker. Probably not. It's special circumstances. So you want to get that checked out before you decide you're not going to pay your employees overtime. And of course, we're talking about non-exempt. We're not talking about exempt, because exempt are always not eligible for overtime pay. Okay, this is kind of confusing. So anybody that's not an HR professional or not an attorney would have kind of it would be difficult to understand this particular law. Calculation of overtime on bonuses. And they're saying non-discretionary flat sum bonuses. So that means that they are optional bonuses. So that would include such things as a retention bonus, a sign-on bonus, anything that is not tied to performance would have to be considered in the same pay period that the employee receives that bonus to be included if that person works overtime. That's the computation. The overtime rate is based on regular non-overtime hours in the pay period instead of total hours. So I have the formula there. You divide the bonus by 40 hours. So say it was $1,000, they divide that by 40 and whatever that number is, that regular rate, and multiply that regular rate by 1.5 times, and then multiply that figure by the number of overtime hours would be added to their overtime. And if you guys want to know more about that, you can always schedule a consultation with me. I'm happy to answer questions on that.